direct examination is really just giving facts to support your case. I've sent out some materials that has a pretty detailed outline of what I think is important in terms of direct examination. And so you'll have copies of that, and then some attachments that I'll go over here in a little bit. Direct examination is another one of those areas. We talked about this a little bit about opening. It's one of the few areas that you can really pre-plan cross-examination while you have ideas of what may come up or what you need to do. It's much more adaptive. Direct examination, because it's your witness, because you're going first with them, you can script it. And I really do encourage scripting your direct examinations, at least to start with. What I've included here in that is some witness worksheets that I've used for law students, and I know some attorneys use these, and you all have copies of those in your email. But it really talks about really focusing what you want this witness for, what you need to get out of them, and the means of which to do that. So those can be extremely helpful, because planning out your direct is really important, because you don't want to just put a witness up there to put them up there. You're putting them up there for a reason. And the reason you're putting up there is to get certain facts that you need to support your case. Now, it could be the biggest time when you actually have elements, right, is on certain affirmative defenses. You need to get out certain things about reasonable fear. You need to be able to check those elements off so you can effectively raise those defenses. Or duress. The other area we see it a lot that we need is when we're putting on expert witnesses to support various defenses. We'll talk about experts here in a moment. But before you start drafting your examination, you really have to know your theory of the case. We talked about this with the opening statement, is what's your theory? How does this witness support that theory? And then again, as we talked about, theme. What's the theme of your case? What is the general ideas you want the jury to walk away from having heard from this witnesses? So when you're plotting this out, you think about what is your theory, what is your theme, what are the strengths and weaknesses of this witness, and really what points do you want to make? I always think you really want to limit yourself to the things you have to get out from your witnesses. The worst thing you can really do is ask that one question too many, or get into that one area that you don't really want to. You can control that by really controlling your questioning. Think of the 3, 4, or 5 points you need to get to this witness, and then really focusing on those, and really focusing your direct script on how do you get that information. Your witnesses are also where you get your exhibits out. So if you're introducing exhibits, you have to know what witness you're getting them in through, how you're getting them in, how you're responding to objections, both to the witness's testimony and to any exhibits that you want to get in. So that when you're done with your examination, you can look at that outline and you can see where you've checked off the things you need. And it's really important to do, because it's very easy in trial to lose track of where you are in the process, especially when you're scripted. And this is where I'm going to talk for a moment about getting off script. But you need to make sure if there's something you need from this witness, you've got to be able to look back and know you got it. Because if you don't get it through your witness, you don't get to talk about it in closing, which is where everything really comes together. So having that, both the script, and I would also suggest a checklist, especially with exhibits. Did I get exhibit 1 in? Did I get exhibit 2 in? And that's going to really help you so that you can keep track of that. I also think direct is a great time to have that script and that checklist to refer to. The jury's not going to hold it against you for checking back with that. And you're not wasting time by doing that. Sometimes when you're up in front of a jury, it's easy to feel like every pause is an eternity. No one really cares. No one minds if you take a moment and look, or take a moment and orientate yourself, and then get back to your examination. So don't be afraid to do that. Don't be afraid of those pauses, because they may be the moment that you catch you've missed the thing you really, really needed. And then you're thinking a little bit about what are you anticipating on cross-examination? What is the prosecutor going to cross your defendant up on, or your witness up on, or your expert up on, So you can be prepared to respond to that both as a part of your direct itself and with relevant objections that you may want to make, because that's when it shifts and then you become the objecting party on cross-examination. So really think through your witness and their testimony before you put them up there. And you can do that in the process as you're creating this. Some of the things I talk about may seem basic, but it's not always, especially if you haven't done many trials before. You tell the court who you're going to bring up. They're going to take the witness up. Typically the clerk or the judge will swear them in. They'll usually state their name for the record. And then it's your show. I read an interesting thing that talked about that the first 15 seconds with your witness is the most important time, because it's when the jury's fully engaged. And that's when you're really going to want to get into who are you and why should the jury care. So essentially, who are you, a little bit of background, and then what's your relationship to this case. If it's the defendant, it's going to be a little obvious, right? But if it's a lay witness, someone the jury hasn't heard from before or hasn't heard from yet, it's good to kind of get that out the way. We don't have to beat around the bush with that, because you always then go back, right? And then walk the witness through things like their training, their experience, their relationship to the parties, things like that. So, I think, again, chronological approach is really good once we get into the meat of our directs. I think that helps the jury create a really clear picture. It's going to help you when you're going into your closing argument. You can say, well, this witness testified that on this date they saw it this time, and then they observed this. And the clearer you can make that is good. Expert witnesses are a little different, and I've got some distinctions there. You start with some introductory questions with your witness after we know why they're there, essentially. Get them comfortable, because your witnesses are going to be really uncomfortable. It's very hard for people to be witnesses in trials. And so you want to be aware of that. You want to establish that rapport with them. And you can be generous. You can start. Right, tell us about yourself. Where do you work? Where do you go to school? These things that aren't hyper relevant, but they're ways to get them into the groove of answering questions. What I always tell a witness before I put them on the stand is, I'm going to be asking you some questions. I'm just going to ask you to, this is before they're ever on there, I'm going to ask you to just listen to my question, answer to the best of your ability. Don't feel the need to go beyond, just answer the question that you are asked, and we'll keep moving on. And that just helps them, because some witnesses are just going to talk, others it's going to be like pulling teeth, and you want to limit both those, because if the witness is going too far afield, you're not controlling your direct. If they're being too brief, you're not getting your information. So do everything you can to establish as much rapport with the witness as you can. The most difficult part of direct, I think, is that we have to ask open-ended questions. Leading questions we get to do on cross-examination. Direct has to be open-ended. Open-ended are things like what, how, where, what did you see, how did that make you feel, where did this happen, right? As opposed to leading questions. So you say, you waited for 15 minutes, right? That's a leading question. How long did you wait? 15 minutes, and so they're different questions. One's appropriate, one's not. I like to get away with leading questions when you can, and even the rules allow some leading questions for foundational purposes. But if you just are doing leading questions, you're going to start getting objections that are going to be sustained. It's going to throw off your flow, it's going to throw off your witness, and it's going to potentially impact how the jury views the witness and yourself. For a lot of the trial, we are center stage. We talked about an opening, that it is a performative action, that we are kind of the star of the show a lot of the time. Not on direct. Your witness is the star, because the jury needs to be listening to them. You want your witness to be the person that knows the information, or otherwise, why are you calling them up there? So if you're saying, you waited 15 minutes, didn't you? Well, you're saying that. Is your witness really saying that? And it helps to establish their credibility. The more they can be responding to those open-ended questions, the better. you want to help the witness shine, you want them to seem believable, and you want them to get out the facts. So I think it's really important to make sure that you let your witness do that. Let the witness's answers breathe. Let them be the star of the show at that time. You also want to help them do that. Your job is to help your witness. And that can be if they've said, well, on February 3rd, I was walking down the street and then I saw two guys running towards me. That was probably going to be 4 questions for you. And then you stop, but you never look like they did anything wrong. So you're like, well, that's very interesting. Can you help me unpack that? Or let's talk about that. You said you were walking down the street. Let's talk about it. Help direct them. And it's going to help them focus that they know you're wanting to go one step at a time. It's going to help your jury. So don't be afraid to take those pauses and direct them where you want them chronologically, but don't do it, I would say don't do it in a way that makes it look like they're idiots, right? You don't want to be like, well, hold on, now you're going too fast. They're never doing anything wrong. It's all you. If you ask a question and they say, I don't know, I don't understand the question, I always say, that's my fault. I probably asked it really bad. Let me try that again. And then you go back to it, because you're always propping your witnesses up. For the most part, there's of course exceptions when you want the witness to go bad, but generally you're not calling those individuals on direct. Directs are all about practice, revising, making sure you're getting the questions that give you the answer that you need to make your case. And so you may go through multiple revisions of your direct. Now, you don't get to sit there with your witness necessarily and say, well, what if I ask you this? What if I ask you that? Ideally, you'll have some amount of witness prep to do that, but in the realities of your job, you don't get every witness to sit down with you for an hour to go over their testimony. So practice it with yourself. If I ask this question, what's the answer to it? Based on what I know from this witness, based on my interviews, based on their previous statements. And keep working through that so that you know that when you get done with that questioning, you ticked off the 3 points you want to make, or 4, or however many that is. And practice it. Direct is a great one to practice because we get to script it. We get to have an idea of what's coming. So you may, driving into work, direct examine your passenger seat, direct examine someone at your house, direct examine your office workers. That can be really helpful because it's going to get you comfortable with it and help you understand, are you asking a good question? Keep editing, keep advising, and talk to people in your office. That's a great way to say, hey, I'm going to ask the witness this. Just any issues with that? And say, well, you are opening the door to something else if you do that. You might want to rethink how you're phrasing it. And so that can be really helpful. Keep your sentences short when you're asking questions. Avoid compound questions, not only because they're objectionable, they're confusing, and you'll never get probably the answers because they're trying to suss through that. So the shorter you can be in yours, the clearer, the more concise, the better. You've got time. No one's going to rush you, and it's okay to go step by step. Sometimes you have witnesses where you do just want to open up and let them talk, especially experts, when you really know what they're going to say, they're really good at it, and they're practiced. But for the most part, we're dealing with a lot of lay witnesses. We're dealing with a lot of defendants that may have never testified before. And so you're going to want to be there to walk them through the process without look like you're walking them through the process. And you do that by asking really clear questions, and that's really helpful for your jury. When you're on direct, for the most part, you want to be as buttoned down, at least in my opinion, as at any other point in the trial. You know, there's times to joke and jest, and sometimes those things happen naturally and organically, and you're doing fine. But you're not trying to make points. You're not trying to, again, be the star of the show. You want your witness to be the star of the show. So try and keep it as professional. With witnesses, I always think of the old cop show. It was just the facts. Right? You want to just be just the facts, man, just the facts. And so you're taking some of that personality out of that in that process to let your witnesses shine. You want to avoid legal speak, I would say, because not only can it confuse your witness, it can confuse your jury. And you might start commenting on the ultimate issue. Were you in reasonable fear for your life, sir? objection goes to ultimate issue, or what do you mean, what's reasonable, it lends itself to being problematic when it's just, how did you feel? And did that make you feel threatened? Why did that make you feel threatened? And so by avoiding the legal mumbo jumbo, so to speak, you're allowing your witness to clearly understand you, the jury to understand you, and you're avoiding potential objections in that. And a commentary. We're going to watch an example next week, I'm thinking, that's going to show how commentary during cross-examination can be effective. It's not as effective during direct examination. Like if they, there's still times when you may do that, when they say, yeah, the car was blue. The car was blue. Wow, that's interesting. You might use that a little bit if you really want to direct to that, but you want to avoid that too much because then it becomes your show, becomes your testimony, and you want to leave that for your witness. The big one, I think maybe the most important thing of direct examination is do not ask a question you do not know the answer to, because you don't know the answer. If you don't know or reasonably know what the answer is going to be, don't ask it. And there's going to be temptation to do that. And then but if you are just trusting, you get a feeling, and I've seen it work before, but it works, it only works a little bit of the time and it backfires a lot of time. So know the answers to the questions that you're asking, because you should, because you're presenting this witness to get these specific facts out. And the moment you go off that, not only are you opening yourself up to questions that may be ultimately damaging to your case, you're potentially opening the door for the prosecution to go in that. That's the other thing to think about is cross-examination is supposed to be limited to what comes out on direct examination. And you can sometimes limit cross by not getting into certain areas. And when they start to, you can object and say, outside the scope of direct. If you ask the witness the question that leads to that, you don't get that option anymore. It's hard. Judges generally are going to allow a lot of leeway on cross-examination because you really just have to make a tangential connection to the direct testimony, but it's still an option, right? If you have a witness that you're bringing in to testify about a contract, let's say, and they also happen to see the defendant being arrested that day. Well, if you never talk about them being arrested that day, and you only talk about that contract, and then the prosecution wants to get into how you saw the defendant being arrested that day, objection outside the scope of direct. You have a good chance of keeping that line of cross-examination off the board. So something to think of, especially when you're preparing your questions. What cross questions will this lead to? The other thing to think too is you do not win the case on direct. You need it because that's the way you get your facts that you will eventually argue in closing. And we'll talk about this in cross-examination, that some people try and win their case on cross by having the Matlock moment. In all the trials I've done, I've never seen someone under cross-examination all of a sudden go, yes, it was me the whole time. It happens on TV, but it does not happen in real life. So don't try to get that moment, and don't try and get it on direct. You don't need to. That's for your closing arguments. The other really important thing, and this is where you have to balance the script versus the reality, make sure you're listening to the answers. Because when you've scripted something as tightly as you probably should your direct, you sometimes just move through. Okay, what color was the car? Red. All right. And when you saw that blue car, where was it going? You got to listen, because the answers should still inform your next question, and they should inform whether you actually get to check that box or not. And this also goes to know what your witness is supposed to say. What did they tell you in their interviews? What did they say in their statements, let's say to law enforcement? Know those things so that if they deviate, you can do one of two things. One, if the deviation is different from what they indicated before, you can now impeach your own witness or refresh their recollection. Let's say they provided a written statement before and they said the car was blue in that statement, now they're saying the car's red, and that's important. You may go, well, you made a previous statement here, correct? Would it help refresh your recollection to refer to that? They do so, that, oh, it was blue. So now it's just a slip of the tongue as opposed to a changing fact. Or you can impeach that if they're digging in. No, it was red. You made a statement to law enforcement, didn't you? And that was closer in time to this incident, wasn't it? And at that time, what'd you tell the officer? You told him it was blue, didn't you? Now, you can impeach your own witnesses. It's better to make it look like you're refreshing their recollection, to continue to prop them up as you can, but it's necessary, especially if it's an important fact. If it's minor, you can let them go. You let the little stuff slide, the big stuff you can't. So you have to listen to the answers, though, to know if you need to take the moment to refresh, to impeach, to give them a moment to maybe think about that answer. So don't be afraid to do that, but you could only do that if you're listening. And make sure they didn't miss anything. If they just skip a fact, you can say, well, you talked about the men running down the street towards you, but you didn't say how many. How many were running down the street? 2, right? So you know if they've missed something. That's important to your case, that you need to make that. The other part of it is, how do we adapt to objections? Objections are great when you're making them, but not as much fun when you're responding to them, because whether they're granted or not, it can completely throw off your questioning. So if there's an objection, you may win the objection. And seriously, 7 times out of 10, after winning on the objection, the attorney still just moves on. Make sure you ask the question again. Make sure that the juror got to hear the answer. Make sure the answer came out. Because depending where it was in the testimony, the juror may not have heard it. The prosecutor might have been objecting over what you're saying. They may have answered, but no one heard it. Or they may not have had a chance to answer. And the great thing about that is it gives you the chance to ask the question again. And if it's something that's being objected to, it's probably something you want the jury to hear more than once. It's the answer's so nice, you want to hear it twice. So if you get a chance to re-ask, always go back and just say, just in case the jury wasn't able to hear you, or just in case I missed it, how many men were running down the street? 2. 2 were. All right, thank you. And your organization will help you with that too, because you'll know if you got that or not. Just don't be so in the moment. Don't be thrown off by objections that you bail on your entire line of questioning. Be responsive to that. Transitions. It's great to have clear transitions on your direct examination. And the reason for that is it's going to let your witness flow with you. It's going to let the jury kind of understand the flow. There's several ways to do transitions. You may pause. It might just be a moment where you take a moment, especially if you're stuck at the podium. You may pause and be like, okay. Now, on to the next day. You transition. You know the juror, you're directing your witness that you're moving on to a different area. You may use your body movement. All right, we're talking about this contract. Right, now I want to talk to you about blank. Or you may just move and say, okay, so how many men was it? What did the contract say? Movement is important because it can help create those transitions. It can help you emphasize your point, especially on direct, though. You don't want your movement to become the show. You don't ever want to feel that you're impeding the witness's view from the jury. You want the jury to be looking at the witness. Oftentimes, I sometimes do direct standing next to the jury box. So they're looking at me, they're looking at the jury. We're keeping that connection. We're both hearing the testimony together. Or you may at times stand next to your client. So the client can see, you can see, and the jury can see. You never want the jury to feel like you're blocking the witness from them. It just sends a bad visual cue that you don't mean, but it could be inferred. And you don't want the jurors worrying about not being able to see the witness, because every juror wants to see the witness. Because everyone thinks that if I look at somebody, I know, I can tell if they're lying. I can tell if they tell the truth, right? So you're talking to your juror, to your witness for the jury. Exhibits. Exhibits are important because they're obviously, if you have it as an exhibit, you want it in for a reason. But you can only get them in through your jurors, typically. Your witnesses, excuse me. So you have to know what exhibit you want. Think of your exhibits exactly like your direct. Why do I want this? How does this support my theory? How does this support my theme? How do I get this in? And so you'll have that checklist. That I know that with Miss Allison, I want to get in the picture of the blue car. And think of the objections to that. I present her with this picture to the blue car, how are they going to object? Are they going to say relevant? Well, this color of the car is relevant, Your Honor, because our theory is it was a red car that ran this guy over. Base of knowledge. She knows what the blue car looks like because she personally observed it. And they may say, well, she didn't take this photograph. They don't have to take the photograph. It just has to accurately depict something of which they had personal knowledge of. So think about what objections are you going to get as you're trying to get those in, and make sure you get it in. Because you don't want to get to closing and then have the clerk say, oh yeah, number 6 was never admitted. And then you're just like, really wanted number 6, but it's not that. So direct is your show to have to control what comes in and what does not. Don't assume you're going to get a redirect. And don't assume there's going to be a cross-examination, because there's often times where, for whatever reason, an attorney will decide not to cross-examine a witness. And you don't get to stand back up and say, oh, I've got a couple more questions. Once you're done, you have to assume you're done. So everything you needed, you need to get in on your direct. Don't think, I'm going to keep this really great thing, because I'm going to get a redirect, and then I'm just going to boom, blow it all up, and they're not going to get across, and it's going to be great. If they decide not to cross, or they cross, but they don't cross in an area that you get to respond to, because your redirect is a response to cross. So if you think that you're going to get the car color in on redirect, and then they don't ask about the car, you don't get to say, oh yeah, by the way, what color was that car? Objection outside the scope of cross. And then you don't get to talk about it. So win your case, get your information in your direct. Don't assume anyone else is going to give you the opportunity to get back at it. Now you may, and the reality is usually there'll be a cross, you'll get a redirect, sometimes you get a re-redirect, but it really depends on the judge, depends what time of day it is, depends on if the jury's getting antsy, depends on a lot of factors you don't get to control. All you get to control is what you ask that witness in that moment, at that time, and after that you have to just assume it's over. I tell my clients and witnesses that direct examination is just a really awkward way of telling a story. Because that's what it is. It's, what I say to my clients is, it's you telling what happened by me asking you questions about it. And it is awkward. And oftentimes witnesses just want to get their whole story out. So you have to figure out, how do I help them tell this story one question at a time? Because the moment they start to go, it's going to be objection, narrative. It's a silly objection in the sense that, well, ideally this information will come out anyways, but it's great for stopping a witness that's saying a lot of really stuff that you don't like as the other side. So people use it because it's an easy one. It's an easy one to win on. And it throws off the flow of that witness. It can throw off the flow of your questioning. So how do I tell this story one question at a time in the most compelling way possible, getting the information out I want, but not going so far that I'm opening the door up to all these other areas. So, as much as you can appear off script is important. In the areas that you do get to have scripts, typically opening and direct are really the few that you do for the most part. You want to appear that you're off them as much as possible. So when you're doing your questioning through practice, you can have a lot of it memorized. I still think it's really important to check back, right? Check back, make sure. And you have to listen and be adaptive, and then get back to your script. You have to be prepared that you may go into a fruitful area that you didn't think about, but don't forget to get back to what you need, because that's the stuff you needed. That's why you have to have this witness there. So you get that. Body position, everything like that is just the same things that I would suggest for opening, and that present yourself confidently. You're going to be a little more withdrawn, I think, on direct because you're letting your witness shine, but you're still thinking about your posture, your movements, because the jury's seeing that. If you're slumped over, if they ask a question and you go, they're like, oh, you didn't like that answer. You just got to keep your control, be intentional with all your movements, just as I would say in opening or any other part of the trial, all the trial, frankly. and don't do things that are distracting within that, as we talked about movement. Yeah, everything just needs to be professional. And professionalism, I think, is the key with dealing with any witnesses on both sides. Your job is to be the professional in the room. Your witness may cry, your witness may get upset, your witness may be emotional. You don't need to be, and nor should you be. Not now, not on your crosses or your directs. You want to be the professional because you want the jury to say, okay, they're just presenting the facts. There's the emotion, there's the real human feeling. We are just eliciting this story because it's what happened, it's what's true, it's what the witness saw, it's what they observed. So don't insert yourself into the narrative, just be professional. And when you treat witnesses well, even when they're not yours, but especially when they're yours, it lends credibility to you, it lends credibility to your client, it lends credibility to the case itself. And we'll talk a little more about that on cross-examination discussions. Let's shift focus a little bit to the direct examination of expert witnesses. Experts are great because for the most part, they've done it before. Experts are problematic because for the most part, they've done it before. So you really have to approach your expert witnesses in the same way because they run the same risks, that they will go too far, or they'll say too much, or they'll get too far off base. So you prepare it in the same manner that what do I need from this expert? What do I have to get from them? What questions get me there? The same scripting and all that. The big part with expert witnesses is first understand how experts get to operate pursuant to the rules. So you need to understand how 701, 702, 703, 704, 705, you have to know those standards. Because those are the things that are going to let you know, first up, is this person qualified to give an opinion? Because that's usually what you call an expert for, right? Why are they qualified? Why does their opinion meet the certain standards, such as the Fry and Daubert standards that they need to make to be even allowed to give this opinion? And then what do they get to comment on? Some experts, depending on the situation, get to comment on the ultimate issue, which is a real important thing if you're commenting on a defendant's mental state, potentially, or if you have a self-defense expert, they're going to talk about things that most witnesses don't get to. But you have to know what lets you get there to allow them to do that. So you have to understand the extent and limitations of your expert. Really, one of the most important parts of your expert's testimony is going to be, why are they the ones, why should we listen to them? What's their training, what's their background, what's their experience? And this is an area that you won't focus on as much on lay witnesses, but I think you should take all the time in the world with an expert witness to walk through, where'd you go to undergrad? And what'd you study? Oh, you study chemistry. And how has that helped you in your career? And then where did you go? Oh, you went to graduate school. And then what did you do? Really experience that. And then what did you do professionally? Okay, so you worked as a chemist for 20 years, right? And break that down a little bit. And in that 20 years, did you deal with the testing of narcotics? Did you look at multiple different controls? You really want to delve into their background so that by the time they're done with that, the jury is thinking, this person knows what they're talking about. And that's important because to be an expert, you have to have knowledge outside the province of the average juror. And so you establish that within that inquiry. So take your time with it. Don't just be like, okay, you're an expert in chemicals, what did you find, right? So take your time in eliciting their background, their experience, their training, and then you move into, did you apply those methods to this case? And then talk about how they applied that. And then you're building to the ultimate thing is, what opinion did you develop? And then at that point, they should be an expert witness, right? You may get the objection. Your Honor, this witness hasn't been tendered as an expert, or this witness doesn't have the background or experience to be an expert. At which point you're like, absolutely they do. We heard all about their training, their experience, all the time they did this, 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 and this. You've always done all the work. Different judges do different things in terms of tendering of an expert. The question of whether to tender an expert or not is really varies, I think, between court to court and judge to judge. I'm still not exactly sure how judges here do it en masse, so I prepare for both. And tendering the expert is essentially when you get to the point where they're going to make their opinion. You say, Your Honor, I'd like to tender this witness as a expert in the field of chemistry, or maybe specifically, I tender this witness as an expert in the field of chemical analysis of narcotics, at which point the judge will look for an objection. That may come, you may have to explain how you got there. Some courts don't want you to tender an expert because some judges, some attorneys, some people feel that by tendering them as an expert, you're giving undue weight and credibility to their testimony. So it really just depends on your judges. If you have an expert that you're planning to present, you may, in your motions in limine, just ask, what's the court's preference? Do you want us to tender experts, or do you want to just let their expertise speak for themselves, subject to relevant objections? And then you don't have to wonder. You may not want to have that discussion in limine if you kind of just want to see it's developed, or you don't want to put the state on notice too much about this person's, that this could be an issue. But again, rules of evidence require you to give the material, so they're going to know you're calling an expert, right? And that's for the really technical experts, the ones that are coming in specifically for their expertise. It's possible all of us here in this room are an expert on something, because all of us have experience or training outside the province of a normal juror, and then it's just a matter of that would be helpful to their defense. Ms. Allison, do you have any experience in playing poker?
I would say that I have some experience in playing poker.
Some experience?
Some experience.
And for how many years did you play poker?
Approximately 7 or 8 years on a weekly basis.
A weekly basis, so you played cards weekly for 7 to 8 years?
Yes, I would estimate on that weekly basis it was approximately 10 hours a night.
So you would spend at least 10 hours a week for 7 years playing poker. Your Honor, I'd like to tender Ms. Allison as an expert in the playing of poker. And we could. She doesn't have to go to poker school, right? We would just proffer that she's got training and experience that is outside the province of the average juror who may or may not have ever played poker to the degree to which she has. And then she can tell you, am I bluffing or not? Always. Almost always. So anyone can. So you may come across, you have a lay witness that you never expect, and then you may want to use them as an expert. This is you see this in the, My Cousin Vinny, right? We referenced that last week in openings, but the pause attraction, it's a great scene where this individual is qualified as an expert in automotive repair, right? She didn't go to school to be an auto mechanic, but she indicates the thing, my father was an auto mechanic, my grandfather was an auto mechanic, his father was an auto mechanic. So be prepared for that, because you can get to that point that you are following the same principles. It's the same ER 7.0, whatever rules that you're relying on to do that. So be prepared for those moments when you need to do that. I once asked an officer if he had specific training and experience in watching Saturday morning cartoons. And he kind of, but you did watch Saturday morning cartoons, didn't you, officer? Yes. And what was the character of Popeye famous for? Which he equivocated and said, eating spinach. I said, officer, what was Popeye famous for? He goes, fighting. Because the guy we were blaming this on was wearing a Popeye shirt, so it would seem to indicate that he may be an individual that was proceeding to this situation with the intent to pick a fight. So, that's not quite fits the thing, but it's a funny story, so I tell you. So, just be aware. And the other thing with your experts is you really want to let your experts breathe too, because you cannot try and look smarter than your experts, right? Because otherwise, why'd you call them? You really want to give them a lot of deference as they're testifying so that they can engender as much competence and confidence for the jury. So, especially when you're asked a question, and that's a really good time too. You always want your witness to be smarter than you, at least from the jury's perspective. So when they say something that's like real technical, whoa, first off, I'm just a simple country lawyer, Dr. Sheboygan. Can you help me understand that as if I was a 6-year-old? And it allows them to be the authority, and you're just the dumb lawyer that you actually probably are. Well, not you guys, me. You guys are all smart. So, experts, very important, understand the rules, read your rules, know how this person, why this person is an expert, why it matters for this case, and what you want to get from them. And just craft it the same way you do with your lay witnesses. The next thing I'm going to move on to is making and responding to objections. Direct is tough because this is the time you really get hit with objections. We'll talk a little bit about the choice of making objections when we talk about cross-examination, but responding to objections can be very difficult because you're in the flow, you've got your script, you know what you want them to say, and all of a sudden, this guy next to you is just shouting at you and pausing and interrupting, and it throws you off. First off, it throws you off just because it's stopping you. It's impeding your flow. It's impeding your progress. The second thing is, if you don't know how to respond to it, you may not get to answer that question, or you may not get to get that answer, depending where you are. So it's very important to know your rules of evidence as much as possible. And you can script this a little bit as you're going through your direct. Okay, how would I oppose this? How would I oppose this question? How would I oppose this answer? Because the question could be objected to, the answer could be objected to. Sometimes things get objected to for no reason, but you still have to be able to respond to it. So understanding what objections may be coming can give you a head start, because then you're going to be able to say, respond. Responding to objections, I think the best way to respond to an objection is rule and reason. One sentence. The more you talk in response to the objection, I think the more likely you are you're going to talk it into being sustained. So if they can say, objection, this witness is an expert. Say, Your Honor, Rule 702. This individual has specialized training and experience in the field of chemistry that will help the jury understand the evidence here. It's one sentence, ideally, that's all you need. Some judges will give you that. Some judges will sustain without giving you any opportunity to respond. Usually in court, you don't get the opportunity to say, well, Judge, I've got a response for that. Usually you just have to rephrase. And maybe you have to rephrase a bunch of times. Maybe you just have to keep going back to the well until they let you explain why you were right. You can sometimes ask, Your Honor, may I be heard on that issue? Judges don't like large objection moments because most of them require the jury to be removed. It used to be you could do a lot of them via sidebar, but with Bone Club and things like that, we don't have that opportunity really at all, and we probably shouldn't because of the open courts issues with it. So they're not going to give you a lot of time, so that if you know the rule, if you have a one-sentence reason why the question's proper, great. If you get sustained, or the objection is sustained, think about asking the question in a different way. That's the best thing. A lot of people, when they get that sustained, it feels like, oh, this horrible loss, and I suck, and I should quit and go sell ice cream. But really, all you really need to do is think about, okay, well, how do I ask this in a non-leading way? How do I ask that doesn't call for an opinion? How do I make this not a compound question? Go back to it. Worst case scenario is they object again, and the judge sustains again. So what? It doesn't matter, ultimately. So don't be afraid to try and approach it from a different way before just abandoning the line of questioning. Or is there another question in this series that would be helpful? If I'm trying to certify this person as an expert without giving them their background, what if I step back and go back to their background? So we think, don't just give up because it feels like a loss. No one ever wins or loses trials at the objection phase. No one's ever had an objection sustained and then the judge says, well, he finds guilty. Let's all go home for lunch. It doesn't happen, so don't let it beat you up. And they'll eventually know when you need just to move on. It's an area that you've done what you needed to, you can't quite get to it, just be like, okay, but do it on your terms. What I mean by that is, say, all right, let's talk about something else. Look like it doesn't affect you. Look like it wasn't even really that important anyways. It was just our entire self-defense case, but I don't care about that. Move on to what your other point, and that's why it's important. What other points do you need to make? That's the other thing. I've seen a lot of direct examinations end on objection sustained, sit down. Don't let that happen. You don't need to. That's your floor. You don't let them get to pick the last thing you end on, right? get back to what's your theme, what's your theory. That's another way that sometimes themes and theories can help us out. What's your buzz phrase? How do you get back to that with one final question, right? So that when you're done on your terms. And then you get to object to them when they're cross-examining. So be prepared. The best way to get good at something is to get good at it. So practice, practice, practice. Redirect. Redirect's interesting because it is limited to their cross-examination. So your redirect is a response to the cross that has just occurred. That's why I say don't save anything you need for redirect, because you may not get there. Redirect, I really truly believe it's very important to have a plan for your redirect. Have 1 or 2 points. That's all you really need, because you've already had your full direct. So you shouldn't need that much more opportunity. Have 1 or 2 points or facts that you need to get out, whether it's a clarification, whether it's a reiteration, whether it's an explanation. Have them, get them done, and sit down. Because your jury's going to be losing patience at this point. They only can listen for so long, just as we all call. I mean, we already have attorneys walking out of the room here, So imagine how how jurors feel when it's just a series of back and forth questions. So your redirect has to have a plan, and it does not reiterate your direct examination. It is not retread the cross-examination. It is to make a point that cross raised. So go up with a plan, think before you speak, and get those points, and then get out, right? So make it responsive, make it meaningful, make it quick. That's the best way to do a redirect. And that's also important why, again, listening. What were the answers on cross-examination, right? What did the witness say? What did they say that you need to clarify? Is there something? I think if you have an opportunity for redirect, you should take it as much as possible. There are some times where it may make sense just to be like, no redirect, we're good. There's some confidence in that. There's something jurors kind of like about that. It's great to have the last word. If you can have the last word, great. But make your last words meaningful. No one remembers meaningless last words, right? So if you're on your deathbed of your direct examination, which is the opportunity for redirect, don't make the last thing you say cranberries, unless you really like cranberries and you really want to get that out there. Make sure it has a point. So if you can stand up and say something meaningful, great. If you can't, you can let it go. Usually there's something you can say about it, right? You just listen to a whole cross-examination where they're trying to tear your person apart. Maybe they didn't. Maybe your witness did so good that you're like, oh, good, this guy got it, right? So that's redirect. I've included these proof worksheets, and really it's just an idea of thinking about your witnesses. They're great for your trial binders. You just have, what am I trying to get? What are the exhibits? This really helps you understand why am I even calling this witness in the first place. If you don't know the answer to these questions, you probably don't need to be calling that witness, right? We don't call people just to call people. With one exception, we're about to talk about that. And that is your client. One of the few areas that we have zero control over at trial, and maybe no control over, this would be the only trial decision besides bench or jury that we don't get to control. That's whether your client testifies or not. It's a right. It's a constitutional right, and it's an important right. And it's a right that makes sense. It's their case, it's their life, it's their constitutional choice to make. And I tell clients every single time, listen, I cannot tell you to testify or not testify. I can say, I think you should testify, and you can say, nope. I can say, you should testify, and you can say, yep, I'm going to. So there may be times when you're putting your client up there when you really would prefer not to, but it's their choice. And so you still need to prepare it the same way, even if you think it's a really bad idea. And a lot of it is, clients want to be heard. That's one of the great things we get to do in this job is we get to listen to people that haven't typically been listened to. We get to hear people that aren't typically heard. And it's such an important thing when you're doing your client counseling, and that is to create that opportunity, because everyone wants to be heard, but not everyone gets to. Many defendants see the trial as their only chance to tell their story, get up there and let people understand what they're doing. You just have to be careful with it, because sometimes what they say may not be helpful. And not because it's not the truth, and not because that's not facts that don't support you, but because it may open the door to other things. Criminal history that would not come in normally. It might open up areas that you would not usually get into. So I would approach it with the same idea of scripting and control as you would any other witness. And really go over that with your client. Let them know what to expect. Because a lot of people in general, and clients specifically, think they get to get up on the stand and they're going to tell the jury what happened. Like, well, you don't really get to do that. We get to tell our story through me asking you questions. And this is what I'm going to ask you. And this is really, we don't get a lot of time to sit with witnesses and go over witness testimony. And you have to be careful with it, because you never want testimony to feel scripted, and you don't want to be telling people what the answers are, because they have to be true. It has to be the answers. But you can sit with your client and say, if I ask you what color the car is, what are you going to say? What are you going to say about this? And how are you going to respond to this? And you can really work through, and sometimes going through that process, your client will be like, oh, you're right, I shouldn't testify. Or, you're right, I should testify. Because it goes both ways. Some clients don't want to testify just because they're nervous, which is completely understandable. And so you talk to them about that. You talk them through it. You talk why it's important one way or the other. Ultimately, you have to let that decision be theirs and make it clear that it is, because it's an important constitutional right and a huge ethical duty you have to make sure they understand that. But all the same principles apply. Try not to ask questions that you don't know the answer to. Make sure that you limit it to the points that you want to make for your case. Do your best with that, because it is an interesting challenge. I had a murder case that I thought we might have won if my client hadn't testified. But it was their case, and it was important to them, and so they did. It didn't go out the way we wanted it to. They were happy they got to be heard, and so there's wins there too. So it's important things to be aware of and think about when we're thinking about our direct examination, because the client testifying is really the most nerve-wracking form of direct examination. It's good to, I think it needs to be prepared even more so than anything else, because I've seen defendants stand up and say, you got me, Mr. Nagy, take me to jail right now. I'm going to go back to my cell. And at that point, you're probably not going to win that case. So you just have to prepare your client for that as well. Prepare them for cross-examination. They're going to get into these areas that we weren't able to. They're going to get to ask you questions we weren't necessarily able to ask. You have to be prepared for it, and try and make sure they at least understand it as well as possible, so that there's as few surprises as possible. I highly recommend, if you have an opportunity to, let your client go through a mock cross. Get another attorney from your office to come in and cross them up. It can be really helpful, just so they know what to expect, because most people have never been on a witness stand before and never will be. It'll be their first time. Most people don't get to feel what it's like to have a lawyer grill them. So if you have an opportunity to simulate that, just so that they know what it feels like, they know what they can get into and can't get into, they know that it's not going to be a back and forth between them arguing with the prosecutor, and if it is, that's probably not a good thing, right? Really work with them on that. And that really comes down to kind of all your witnesses too, is you tell them on the cross, you don't need to be smarter than the prosecutor. You don't need to try and outthink them. You don't know what their strategy is. You think you do, but you don't. Don't just answer. Answer the questions to the best of your knowledge, to the best of your ability. Don't say anything more. Let them ask the next question. I'll make objections, but my objections can't necessarily save you. And I can't look like I'm trying to save you from that cross-examination, because it looks like then we're not confident in our case. So, especially professional witness, that's a big one. So, but you just have to let your witness be aware what to expect as much as you can, so that they don't get up there and get worked up, get off script, not script necessarily, but off your theory, your theme, out of your case. You want them to understand exactly how the process is going to go. So, All right, so that is direct examination in a nutshell. How did I get in this nutshell? What kind of nut has a shell this big? That's where you put that bad joke sound. Thank you very much. Appreciate it. Questions? All right, we'll take it. I did get a question from our studio audience last week about some reading recommendations. I was like, well, I should probably think of some really good trial practice books to recommend. I got so far as Googling trial practice books really good before I realized I haven't read a lot of those. Everything I've learned for the most part has been through doing, through observing, through teaching, through lesson planning, through seeing other lawyers, trial teams, trial coaches, things like that. So it's been more experiential. If I could suggest reading materials to help you be a trial attorney, I really think it's whatever helps you understand the human condition as best as possible. And what I mean by that is our job is awesome because we get advocates. Most of us have very strong beliefs about justice and people and the way people should be treated. But jurors and that don't always share those same beliefs, and so oftentimes our opposition don't share those beliefs in the same way. So the more you can draw back from that and be as objective as possible will really help increase your trial awareness, because remember, you're presenting to a jury of people that don't necessarily think like you, or they all think in different ways than that. So for me, I really get into Stoicism. It's an idea of sort of a philosophical idea, but you can do the same things with psychology, whatever belief system. There's ways to draw back from the self. And the two books that I really think are helpful as a lawyer, they're by a guy named Ryan Holiday. The first one is Ego is the Enemy, and essentially it's the concept of take yourself out of the equation a little bit. Don't let yourself, egotism get in the way of viewing everything objectively or from other people's perspectives and understanding that. So I think that's helpful. The other book he wrote was The Obstacle is the Way, which I think is an incredible thing for trial because we're always coming up against obstacles. And it's really about utilizing those obstacles to actually create the way through them with them. So the obstacle becomes the thing that makes you great. And for me, those are really helpful. But that goes back to a philosophy that I attune to and try and do that. So whatever helps you understand people will help you be a better lawyer. Whatever helps you step outside of our own narrow worldview that each of us has, even if we're awesome and brilliant as you all are, it's good to try and see things from a bigger picture. So that would be my reading material suggestion. And there's a lot of other good stuff out there, but that's for our studio audience at home. Thank you for your question. Anything else? All right. Thank you all very much. Appreciate it greatly. Next week, cross-examination.